Good afternoon and welcome to today's webinar. We apologize for the slight delay. We are going to jump right into our webinar today in collaboration with Dorsey and Whitney. Today's topic is Prepare for Impact, Buying Groups, Rebate Prices, and the Robinson Patman Act. My name is Brian Munson. I am the Business Development and Co-op Sales Manager for NCBA CLUSA, and I will be your moderator today. As I mentioned, we are joined on the webinar today by Dorsey and Whitney LLP. Just for some quick background, Prepare for Impact is our exclusive webinar series that will explore the key issues shaping our 2017 Impact Conference. Impact will be held October 4th through the 6th in Alexandria, Virginia. And given that rebates are an important part of every co-op and their structure, particularly purchasing cooperatives, we wanted to develop this two-part series that will include today's topic. Our second webinar will be in collaboration with LBMX, and we'll look at sort of the vendor management aspect of this process. And I see a few folks on from Buying Group Services. This whole concept actually was born out of a conversation that they were leading at the Accelerate conference, which is a similar gathering of purchasing co-ops and buying groups that met in June in Toronto. And so just a quick plug for that conference. It's a great event, as will Impact be, and we hope that you're able to attend this fall event as well. Very quickly, a quick bit of housekeeping. Participant lines right now are muted during the presentation just to reduce background noise. You can, of course, pose questions. We do encourage that, just not so verbally. You'll use your GoToWebinar control panel on your screen there. You can enter the question, and we'll collect those and answer them at the end. We are recording this program. It will be archived on our website, and every attendee or registrant of this webinar will be able to get that link tomorrow when we send that around. So feel free to share that with colleagues, friends, family, anyone that you think will find some benefit in this particular topic. As I mentioned, we're joined today by Dorsey and Whitney LLP, and our panelist is Michael Lindsay. He's a partner there. I'm going to let him introduce himself. He's going to run the PowerPoint today. And with that, Michael, I invite you to take it away.
Thank you, Brian. Good morning or afternoon, everyone. My name, as Brian mentioned, is Michael Lindsay, and I am a partner at the law firm of Dorsey and Whitney. I'm based in our Minneapolis office, but we have offices in various other parts of the country. I have spent the better part of 20 years working with a variety of cooperatives, purchasing co-ops, electric co-ops, agricultural supply and marketing co-ops, and have come to have a fair bit of knowledge in this area. So when Brian invited me to give this presentation, I was delighted to accept. One other bit of background for you is that about 6 or 7 years ago, I published an article in Antitrust magazine. It's available at the Dorsey website as well, but it's a broader view of the antitrust rules as they apply to buying groups in particular, whether organized as cooperatives or otherwise. And that's a resource that's available to you. If you can't find it readily on dorsey.com, just send me an email and I'll be happy to send you a copy. So let me just briefly introduce the program today. The program is entitled Buying Groups, Rebates, Prices, and the Robinson Patman Act. And I'm going to provide a couple of introductory remarks and offer an explanation for why you should care about this topic, although the fact that you're already on the call indicates that you probably have some inkling of why you should care, or it's just an area you wanted to know more about. I'll then have some other antitrust pointers on a topic that I see increasingly in the buying group world, and then we'll have time to address some of your questions. My planned remarks should go about 30-35 minutes, so we will certainly have time toward the end of this presentation for your questions. If you type them into the chat window while we're continuing, then I may even be able to address them as we're moving along. So first question, what is Robinson Patman? The Robinson Patman Act is a federal statute that was adopted in the 1930s, and it was adopted to protect wholesalers from powerful retailers. Back in that era, there was a chain called A&P that had become very powerful, and wholesalers did not like having to give lower prices to their most powerful customer. And that's what Robinson Patman exists to protect against. So it's a federal statute that prohibits a supplier from charging different prices to competing resellers of the same product. Now, why should you care about this? I can give you at least two reasons, and we'll discuss a third toward the end. First of all, purchasing cooperatives exist to get better, or at least competitive prices for your members. And knowing something about the ground rules for getting those better prices and understanding the rules that apply to the purchasers who are competing with your members is always useful. And related to that, your members are joining your group, at least in part, because those larger competitors are getting better prices from their suppliers. And by banding together, you hope to try to equalize the playing field. So what does the Robinson Patman Act require in order for there to be a violation? So let me just walk through what are called the elements of a Robinson Patman violation. So the first thing is that there be a difference in price. But price here means the real end of the day price, not the nominal price that might show up on the invoice. So you could have an invoice price, but there's a quarterly rebate. You could have an invoice price, but there's a practice of knocking off a percentage of that price after the invoice is issued. It does include any kind of program credits that end up being awarded to the supplier. So it's the real price. Second point is that it involves the sale of commodities. So it does not apply to the sale of services. There are some state statutes that do apply to the sale of services, but I largely don't worry about those, particularly in a purchasing cooperative scenario. Those commodities have to be of like grade and quality. What does that mean? If it looks the same to a customer, it probably is the same. If it looks different to the customer, then it's probably a different commodity. The sales of those commodities at different prices have to be reasonably contemporaneous. So you can't say that because one person bought something in Q1 at a lower price than I have to pay in Q3, that means there's a price discrimination. Chances are that actually what is going on is that there's been a change of market conditions. But that reasonable contemporaneousness is important as well. One seller and two buyers or two resellers of the product. And I want to stress that, and we'll come back to this in a moment, that this applies to products that are sold to resellers. An internal transfer from a parent to a subsidiary does not count. So if your member's competitor is part of a vertically integrated enterprise and the manufacturing component transfers the product to the sales arm, that doesn't count as a sale. Conversely, if you have two different selling arms of a parent and they are selling into different parts of the market or different parts of the country, the fact that those two subsidiaries have a common parent means they count as a single seller. Now there's one case, it's about 10 or 12 years old now, that says that sales within a purchasing cooperative to its members also don't count as sales for purposes of price discrimination. I tend not to rely on that case anymore. I suspect that it would not hold up today, but it is out there. Because it's a federal statute, at least one of the sales has to have crossed interstate lines. So the manufacturer could be selling to competing resellers who are located in different states, and then by definition, one of the sales is likely to have crossed interstate lines to go either to the reseller who's complaining or to the reseller who got the what's called the favored price. And then a very important qualification is injury to competition, that the price discrimination may injure a competitor or may substantially lessen competition. And we'll come back to that because that's very important. So you're probably thinking to yourself, so how do people get away with charging different prices? Because I see it all the time. I see Walmart is probably getting a much better price than a mom and pop grocery store is getting, or than the wholesaler that sells to that mom and pop grocery store is getting. How does this happen? Well, there are a few ways that it can happen. The single most common defense is what is called meeting competition. And what that means is that if I am the seller of a product and my reseller comes to me and says, I have a better offer for the same commodity from one of your competitors. If you don't meet that price, I'm going to buy from your competitor instead of you. Well, the Robinson Patman Act does not require you to forego business. As a manufacturer, you can decide, you don't have to, but you can decide to meet the competition. Now, what the statute says is meet, not beat. And so what you have to be doing is making a good faith effort to meet competition. Now, I say good faith effort because the world does not always have perfect information. And if you are a manufacturer, you're going to have to rely on the best information that you can get, which sometimes is not going to be perfect. You know, ideally, you would have a copy of the offer that was, a copy of the written offer that was made to the buyer before you decide whether you're going to meet competition. But sometimes the buyer isn't willing to do that, and they're basically inviting you to try to meet competition, and you might overshoot. That's fine as long as it's a reasonable effort to figure out what the price is. The manufacturer should then document it. The sellers, the manufacturer should never, ever call up the competing manufacturer to verify the offer, because that tends to look a lot like price fixing. All right, so all of that is what is called the meeting competition defense. And that's one way that Walmart or some other large buyer can get a better price. They simply play competing sellers off against one another. Another way that they can get a better price is what is called the functional discount. So if I am performing a function, I, the reseller, am performing a function for the manufacturer that the manufacturer would otherwise have to perform, there is a savings that represents, and the manufacturer can roughly account for the value of that savings. The savings that it's realizing by not having to perform this service. So for example, warehousing or picking up at the plant, or further distribution from the warehouse. These are also the sorts of things that can save the manufacturer money, and they're entitled to take that into account in setting the price. Then there's something called functional availability, different from a functional discount. And the idea here is that the discount is available. It's, first of all, it's known to everyone. All of the resellers know it because it's in the published program materials that the manufacturer puts out. And it's practically achievable by substantially all of the resellers. So there's no such thing as a volume discount defense as such. You get to volume discounts and you can defend them on the basis that they're available to everyone, and practically speaking, anyone who wants to take advantage of it can get the volume discount. But that's because of this concept of functional availability. You can't defend a volume discount program that has a break point that's achievable only by one of your 30 or 40 resellers, because that isn't practically available to everyone. You might defend that on the basis that you were meeting competition, and if you didn't give that discount, you weren't going to win the business, but that takes you back to the meeting competition defense. There's another defense that's available for cooperatives, and that's the defense for member rebates. Because when you think about it, if you are a title-taking, reselling cooperative, and some of those do exist, but not all purchasing co-ops follow that model, you might charge a different price to your member versus the non-member. And that different price may well take the form of a year-end rebate that your members get that non-members do not get. And there's a specific exemption in the statute for that, as long as it's being handed out on a pro rata basis, proportionate to the purchases that the members have made during the year. And then finally, I'm going to talk about proof of damages. Now, it's not technically what is a defense, but it's part of a case that someone who's complaining about a price discrimination has to make. You have to prove that I was injured by the discrimination, that the injury was flowed from what made the injury and something that injured competition. So not just I ended up paying more for the product. That's an overcharge theory, and that doesn't work in a price discrimination case. You have to show that I lost sales and lost my ability to compete as a result of the price discrimination, and that can be very difficult. It's easier to prove if your reseller is a limited category reseller. So, for example, you'll see Robinson Patman claims in the automobile dealer industry. You'll also see claims for automobile dealers under state laws that protect them. But that's because it's a lot easier, not easy, but a lot less difficult to show an injury to competition and a loss of the ability to compete with other dealers where you have a limited range of products that you're selling. Where you have a broader range of products that you're selling, it's going to be more challenging, not impossible, but definitely more difficult. All right, so those are the rules as they apply to the manufacturers and other suppliers that a purchasing cooperative is dealing with. And now, why should you care about the rules that apply to them? I'm going to give you 3 reasons. First is there is a risk of buyer liability. So even though it's the seller that violates the Robinson Patman Act, a buyer can be liable in some limited circumstances. And you want to know what those circumstances are so that you can steer clear of them. So the basic rule is that a buyer can be liable if it has knowingly induced the seller into violating the Robinson Patman Act. But the buyer isn't liable unless the seller is liable. So what that means is that when you are negotiating pricing, or if you are a rebate model cooperative, your members might actually end up negotiating pricing, but when it all gets added together, it's the price that your members end up paying. If you have knowingly caused the manufacturer to give you and your members significantly better pricing than that supplier is giving to competitors of your members, then that can create buyer liability. But sometimes what you're doing, as I mentioned earlier, is you're playing the suppliers off against one another. And you will be providing imperfect information in order for them to decide, yes, I want to provide you a better price. That imperfect information will be some of the information that competing sellers are offering to the purchasing co-op. You may not provide a copy of that offer But you may tell a supplier, we are getting better terms, and you are going to have, it'll be more challenging for you to make sales through our co-op if you don't improve upon your terms to match what this other supplier is doing. And in that event, even if you're, kind of stretching the truth but not breaking it all together, the seller is going to be able to rely on that information for its meeting competition defense. And because you've done this in the right way, the seller isn't liable because it has a good faith basis for giving you a better price. And since the seller isn't liable, the buying group and its members aren't liable either. So what would be a clear example of a case where you might have serious concern about a buyer liability case? Well, the best example I can give is what's called an MFN plus. And I rarely see people try to do these, but I have had more than one come across my desk over the years. And an MFN, most favored nation or most favored customer, and that's a kind of clause you're probably familiar with that basically says that I am getting the same price as you are giving to other similarly situated buyers. And obviously the details matter, because similarly situated may mean buying a certain volume or buying a certain number of different SKUs. And so that's where the commercial negotiation happens. Just what does similarly situated mean, and how am I going to phrase that? An MFN plus is one that says you will give me a price that is 10% better than the price that you are giving to any similarly situated customer. Well, now that begins to sound like I have deliberately gotten the seller to give me a better price than what what that supplier is giving to my members' competitors, and that's where you could run into trouble. So all of that is the knowing inducement area, and again, it's something you can pretty easily and confidently steer clear of as long as you recognize that it's out there. So on the opposite side of that is knowing when you're being played, because suppliers are going to be perfectly willing to say, hey, I can't give you better pricing because this Robinson Patman Act prohibits me from doing that. Well, if you know something about what the Robinson Patman Act really does, you're going to be in a better position to be able to respond to that. So, the first thing you can say is, look, I'm not asking for you to give me a better price than you're giving to my members' competitors. I don't care what prices you give them. I'm asking you to give a better price to me than you are giving to me and my members today. What you do with anyone else is your business. Well, that pretty much disposes of that argument. Another response is, so you wouldn't object then to telling me what you're charging those rivals, or giving me proof of that, or making a representation in the agreement that that's the price you're charging to them. You can ask for that kind of information, and then they'll tend to back off, and you'll get a better sense of how much truth was in the statement they were making versus how much they were just trying to game you. Or you can convert this. So you're offering me an MFN clause because you're telling me you can't charge me a lower price than you're charging these rivals. Well, that must mean that you're saying the same thing to everyone else, and so you're going to be willing to give me this clause that actually demonstrates that. And let me see the text of that clause that you're proposing so I can figure out what those volume breakpoints are, and we can figure out whether there are some breakpoints that I can't meet, and maybe then we need to continue our negotiations. And a final thing you can say is, so I'm telling you there's competition out there and you don't want to meet it. That's your choice. You don't have to meet it. I just want you to tell me clearly that what you're saying is I should be taking my business elsewhere. And that typically a seller doesn't like to lose sales. They're in business to make sales, not to lose sales. And so that can also be effective. So all of that is a second reason for wanting to have a bit of understanding in this area. A third reason is simply recognizing potential claims. And so you can recognize claims both for your organization or for your members, depending upon who the actual purchaser is. And those are two kinds of claims. One is a discrimination claim. Now, I am not saying that when you recognize a discrimination claim that you ought to be scurrying off to court, but you ought to be thinking about, are they already doing something that's hurting my members, and how can I use that to my members' advantage in my commercial negotiations? And the second thing you should be on the lookout for is price fixing claims. And again, this is going to be very rare, but it definitely does happen, and it does happen with reputable companies. So if you're sensing some kind of uniformity of pricing among among competing manufacturers, there may be perfectly good reasons for that. For example, when you see the price of gasoline at retail stations going up right around Memorial Day, there's a perfectly good reason for that, which is that demand has gone up and supply hasn't caught up to the increase in demand yet. And so prices are going to go up as a perfectly natural rationing mechanism to draw more product into the market and cause people to cut back on what they might otherwise consume. And even though the price is going up with everyone, it's typically not suspicious. So you might see that among manufacturers, but if you have a sense that there really isn't a good reason for it, that you can't understand just kind of the market reasons why the pricing is so uniform, that's when you might want to get in touch with your lawyer to see, is there something more that I should be suspicious about, or some questions I should be asking? Okay, I'm now going to leave Robinson Patman, and I'm going to go to a different topic that I see more and more. I'm not sure that I've seen it specifically with purchasing cooperatives, so I'm going to spend just a little bit of time on this, put it out there, and if we have questions about it, maybe I'll get a chance to ask some questions back of whether anyone has seen this. Now, where it does come into play, though, with co-ops is sometimes what you're negotiating isn't just price, it's promotional programs. And those are covered by a different part of the Robinson Patman Act, which doesn't have the same injury to competition requirement baked into the statute. You still have to show it, if you want to claim damages, but basically it's a somewhat lighter version of price discrimination. And so what I mean by that is, if someone is providing money for advertising of products, so a manufacturer agrees to co-op advertising for products, that program has to be available to competing resellers. If the manufacturer is, say in a pure retail space, if they're paying for an end cap display in a grocery store, that kind of program has, or something similar, has to be available to competing resellers. But let me turn to the topic that I've labeled RPM and MAP. And what that refers to is resale price maintenance and minimum advertised price policies. So what you'll often see today is manufacturers want to keep the resale prices of their products higher. The reason they do that is, well, several reasons. One, they want to promote the image of their product as a luxury good, and you can't do that at bargain basement resale prices. Or they want to give the reseller an incentive to be promoting their product, either because it's one that requires a lot of explanation, or maybe it's a new entrant to the marketplace, or a line extension by an incumbent in the marketplace, and they want the retailer to have an incentive to promote the product. And you do that by giving them more room in the margin, because they'll be willing to expend some extra costs in order to get that larger margin. Well, they won't do that if the person can walk into the store, get all of the pre-sale education they want, and then walk down the street and buy the same product cheaper. And so that's why manufacturers will adopt this kind of program. RPM it's also called a unilateral pricing policy, applies to the actual selling price, or reselling price rather, of the product at issue. MAP, minimum advertised price, applies only to the advertised price for that product. And it's easy to see what an advertised price is in television or in print. Once you get to the internet, if you go to a website, probably the opening price that you see on the website is going to be considered advertising. But then once you start moving it into the shopping cart, that's where the debate arises, where advertising ends and actual pricing begins. Now, these programs are not self-enforcing. Manufacturers have to take steps to enforce them, and the typical steps are that they will suspend sales for a defined product class for a specified period. And that's on the first instance of non-compliance that they detect. If they detect a second incident, then they will typically expand the products to which it applies, so not just the particular SKU, but everything in that product category. And instead of being for 30 days, it will be for 90 days. And the terms will vary widely depending upon who the manufacturer is. Now, where this plays into purchasing groups is that those programs tend to be adopted on what is called a unilateral basis. The manufacturer will announce the program, but will not seek and will not accept any reseller's agreement to comply with the program. They make their business decision of who to sell to and how much and for how long to sell that product to a reseller. And if the reseller chooses not to comply with the policy, that's fine, in the sense that the manufacturer won't say you broke your promise or breached your agreement, because there was no promise or agreement. You can do what you want, but just as you can do what you want, I can do what I want, and I'm just giving you the courtesy of telling you in advance what I'm going to do. Sounds a lot like an agreement, but the way the law works, that is not an agreement. Once you excuse me, and that's also what is called a vertical practice. So that's between the manufacturer and its reseller. And those tend to get judged a lot more leniently than agreements between competing manufacturers or competing resellers. Those are called horizontal agreements. So that's why manufacturers want to do this. They want to have them be unilateral programs, and they want them to be just between them and each reseller, because then they can say there was no agreement, and if there was an agreement, it's not an agreement in unreasonable restraint of trade, because it's a vertical agreement, and you're going to judge those more leniently. Once you bring that to a buying group, though, it might end up looking more like a horizontal agreement if you have the buying group then going out and getting its members to agree to the terms of that program. So that's just a word of caution. Again, I haven't seen a lot of these, and I will be interested in hearing if anyone is seeing these coming from manufacturers to buying groups as opposed to individual resellers. Okay, and then, since what I do is antitrust work, I'm always kind of encouraged to remind members, buying groups and their members, that your cooperation is on the buying side. And you cooperate because it's in everyone's interest to achieve efficiencies on the buying side. What you do with those efficiencies when you are out there competing in the marketplace is your business as an individual member, and there typically are not agreements as to what you will or will not do with those efficiencies. So if we're free to compete with each other if that's the business decision that we make. Now, there are some purchasing cooperatives that have, for example, a marketing side as well, and they may be organized not just as a buying group but also as a franchisor or franchisee, and that can mean that there are some limitations on what your members do, but you will do that only under a carefully constructed and lawyer-reviewed program. And then, as I said a few moments ago, another antitrust reminder. So now I've reminded you about what you and your members should or should not be doing, and now I'll remind you of what your suppliers should not be doing, and therefore what you should be on the lookout for. Any signs that that your competing suppliers are doing something to fix prices or reduce output by agreement amongst them. Again, it's rare, but it does happen, and some otherwise reputable companies have found themselves implicated in those kinds of violations. It's likeliest to occur for a commoditized product where there's excess capacity on the manufacturing side and a previous downward trend, because that's when people have all the the right set of incentives to try to fix prices and keep them above the levels that competition dictates they should be falling to. So that concludes my prepared remarks, and as Brian said at the outset, it's now time for questions. So Brian, let me hand it back to you.
Sure, and thanks, Michael. This is really informative, and I want to also mention that the Impact Conference has 3 tracks. The first is we're calling the Impact track, and it's really looking at the economic impact that cooperatives have on their communities, essentially. So a lot of those independent, like where this juxtaposes with purchasing, is those independent businesses that are what are they doing within the communities, and understanding these rules and regulations that you're talking about is important to keep them vibrant and competitive. And the second and third track are what I just mentioned, the purchasing cooperatives. That's why we're talking about this specific issue. And then our co-op professionals, which is lawyers and accountants that work with cooperatives. All of these groups will have their own individual tracks with their own topics, but what I think makes the conference very special, and you can probably attest to this, is the opportunity to mix and talk about things like this in sort of that one-to-one way, where you may only get to do a phone call, or we're hearing you on this webinar. But I just want to let folks know that that's what's going to happen at Impact, and that's what's super exciting about it. And so the questions that as they come in, we'll certainly get to those. I guess maybe a standard question, Michael, that I could kind of pose to you to get things started. What kind of penalties could be levied at a co-op if they are found in trying to violate Robinson Patman, or they're involved in something like that? What could it really do to the business?
So what it could do to the business, and let me again stress at the outset of this response that this is going to be a very rare circumstance, because as a practical matter, if the manufacturer has any sense that the purchasing group, are inviting it to violate the Robinson Patman Act, they're going to say no. So you're probably not going to get into this situation ever. And I was simply pointing out that there is the risk. You need to be aware of it. But as long as you behave in what I'll call a commercially reasonable fashion, the odds that you would ever have that problem are very remote. If you did have that problem, though, you would share the liability that the buyer has, that the manufacturer has, and you'd be exposed to a claim for the disfavored resellers' lost profits times 3 plus attorney's fees. And that gets to be very, very expensive. There was a recent Robinson Patman case where, for obscure reasons, the defendant, the manufacturer, won the case, but because of the terms of its contract, it was entitled to recover its attorney's fees for winning in the Robinson Patman case. and that amounted to several $1 million. I've forgotten the exact fee, but the attorney's fees alone could bury a cooperative. And that's why, yes, it's a small risk, but it's one that you don't want to take.
Sure. Someone asked a question when you said title-taking cooperative. What do you mean by that? Is that refer to central billing?
Yes, it does refer to central billing, but there are several different models, and let me just put them out there, and there's a lot of variety that this is going to miss, but at the one end you have a cooperative that takes legal title to the products. It actually receives physical custody of the products. It puts them into a warehouse that is owned by the cooperative. It resells to its members and maybe to non-members. It may sell under the manufacturer's brand. It could sell under the co-op's own brand. A lot of co-ops do that. That's what I would call a title-taking and plus cooperative. You could have something like that where the co-op itself never takes physical possession, but is in the chain of title and engages in central billing. So the manufacturer bills the co-op charges its members, the co-op receives the funding from its members, and then pays the manufacturer. Now, I do have clients that have that kind of arrangement, but they very carefully keep themselves out of the chain of title, and they'll have a specific provision in their agreement with the manufacturer to that effect. And the reason is to try to minimize the risk of a product liability claim coming your way in the future. And then toward the other end of the spectrum, you will have cooperatives that negotiate the price, but the bills all go to the individual members. And sometimes you'll have a cooperative that negotiates a rebate, but that's all it does. And then the members still negotiate actual pricing. So they'll negotiate the price, and then they'll also get the rebate for buying through the cooperative program as well. So when I was referring to title taking, I meant clearly someone in that first category, and maybe some additional ones, but not the latter two.
Sure. Okay. We had a follow-up on the question about being fined or penalties. It says, how many purchasing cooperatives have been fined under Robinson Patman in the last 10 years or so?
I don't think I've seen any that have themselves had to pay either civil damages or that is civil damages in a private lawsuit, or what are called civil penalties imposed by the government for violations, or for that matter, criminal penalties. And frankly, I don't think there's been a criminal Robinson Patman case in my lifetime. But there has been civil litigation. Where I have seen co-ops involved, it's particularly in the pharmaceutical industry and other aspects of the healthcare industry. You can see cooperatives getting involved in litigation, typically as a non-party witness who has some information, and then you get into the expense of having to produce documents and witnesses in response to subpoenas.
Got it. You mentioned earlier in your presentation about sort of defense of Robinson Patman, I think on the manufacturer side, a smaller range of products versus a larger range of products, and correct me if I misquoted you there. A lot of our members, I think, are at NCBA are on the larger side in terms of the number of SKUs they have. What should they be watching for specifically if they have this large range of products, but also a fairly high number of suppliers that they're dealing with? Is there best practices in terms of managing those conversations and watching specific things that, you know, could be sort of easily distilled in saying, hey, if you see this happening, you might want to check these other suppliers if they're doing something similar, or just any kind of like helpful, quick tips that they might be able to put into play.
Yeah, what I would say is if you're seeing identical or nearly identical pricing or other behavior and nearly identical refusals to bargain, that would be suspicious. Because again, you know, if you're a salesperson, your job is to try to make sales, and if the first offer isn't good enough, you're going to try another way to get there. If the seller is not behaving the way that you would expect a seller to behave, that should be an indication that there may be something amiss. Now, that doesn't mean there is always something amiss, because there could be a perfectly good reason. You know, the seller may decide, look, my product is really good, and yeah, I know I've got some competitors, but frankly, their products aren't as good as mine, and I don't feel a need to be bargaining against myself. You know, the price is the price. So you can certainly see that that does happen, and that would not be suspicious.
Gotcha. And I think that kind of gets to some of the points that you were making on, you know, why should a buyer care, and kind of understanding, recognizing those potential claims. I think what I gravitated to was, I think your second point about knowing, you know, when you're being played, I think is the way you kind of phrased it. Right. You know, the idea of kind of having those conversations where you're saying, okay, if this is happening, then I should ask the person this. I feel like, I mean, it takes a lot of thought, and it takes a lot of being able to know the law, but also being able to look at it very quickly and saying, oh, they're trying to go this way. Obviously, you know, that's why we have lawyers, and that's, you know, why you've made your career in this field. In terms of who at the co-op, if they don't have a lawyer immediately on retainer, or if they're on the phone and they're getting haggled with, you know, should they stay on the phone with some of these suppliers that they think are messing with them? Should they jump off the phone and say, I'm going to talk to a lawyer? How should that process kind of work, and who internally at the co-op is really the best equipped to handle that in terms of job description? Is it going to be the CEO, the CFO? You know, who's got the skill set to really deal with those kind of questions if they don't have a lawyer, say, on retainer?
Yeah, so some days I say that people should never leave their homes without a lawyer at their side, and some days I say everyone would be better off if no one ever even breathed the word lawyer. So it really does depend upon the circumstances, and if what you're hearing sounds like you know, someone's just making noise trying to avoid giving you better terms, but you think you can get there, then you stay on the phone and you continue the negotiations until you arrive at the point where either they're saying no or you're saying no. So what I'm talking about here is really simply one aspect of all of the things that go into a negotiation. So you want to understand where your counterparty is coming from, because you know, knowing what they value can give you something that you can offer them, and knowing what concerns they ought to have, and you know, when they're actually just kind of puffing, is useful. But it's not just these legal issues that I'm talking about, it's all sorts of things. You know, you have to figure out what's the value proposition that your purchasing group is offering to the supplier. Sometimes it's just access. Because your members, you know, they won't guarantee that they'll buy from any one provider, but they've got a very strong culture that they'll only buy from suppliers who are selling through the cooperative. Sometimes there's more of a commitment that the members will in fact buy from, because of the co-op's bylaws or member contract. The members have to buy a certain percentage of their products from the co-op, or they have to make purchases from a certain number of suppliers within the co-op. So, we have programs from 40 different suppliers, and each member is committed to buying from at least 10 of those suppliers. You figure out what the value proposition that your cooperative is offering to the supplier is, and that works into it. And all I'm saying with these are, you have to understand something about the mindset of the seller. What are they looking for, and what are the kinds of things they might say in order to avoid giving you a better deal. And this is just, it's one subset that people who are experienced negotiators will know far more than I will.
Sure. Well, I think it plays into sort of the sales conversation. It's obviously slightly tweaked, but nonetheless as nuanced. So that's interesting. We did have a question come in. It says, can you require a seller to disclose the terms or the rebate programs they offer to the other groups or chains? Excuse me. Can you require a seller to do that?
You can always ask, and they will typically say no. And I would not be surprised when they say no, but what you're usually using that for is to test them and to try to get a better price, even though you may not know fully what they're offering to someone else. And from your perspective, you wouldn't want them disclosing to your competitors or your members' competitors the program terms that they're offering to you either. So you should expect the answer no, but use the request as a tool to try to get something that you actually do value. Can you require it? Only if you have a contract that says so, or there is a state law that requires that. And I don't, for the vast majority of commodities, there's no such state law. If you think that you are suffering from price discrimination and it is so bad that you are willing to file a lawsuit, then at that point you can make a request for those competing programs. But that's a lot of hoops and expense to go through to get that information, and you have to have a good faith basis for doing it.
Well, this is, Michael, this is awesome. This is really good stuff. Will you be in attendance at the Co-op Professionals event this year?
Yeah, that I do plan to go this year.
Great.
And I'd be delighted to talk with anyone about it. Yeah,
I want to chat with you offline. I'm going to give you a shout, see if we can get you more involved in the purchasing track. So, this, again, thank you for leading us today through this. Again, the genesis of this conversation came at Accelerate, which is kind of a complementary conference, really, to what the purchasing conference has historically been. And the conversation there was as robust and across many different topics, but this is one that particularly stood out to our members that attended that particular session. And so I thank you for kind of helping us, expand on that, and also for Buying Group Services to be part of that conversation at Accelerate, and of course LBMX, who will be hosting part 2 of this conversation, looking at managing some of the vendors in terms of how that conversation goes. So all parties involved, very smart, very talented folks, and look forward to seeing everybody at Accelerate. With that said, to everybody that's on the line, if you're looking for more information about impacts or purchasing co-ops, please contact me. My email, bmunson@ncba.coop. You can, of course, subscribe to our weekly e-newsletter, the Co-op Weekly, that has all the info about the Impact Conference. If you're curious and want to go right now, you can just go to ncba.coop, go to the Events tab, and you will find the Impact Conference there. We will be in DC October 4th through the 6th, actually in Alexandria, Virginia, so just outside DC. But Michael, it's been my pleasure to talk to you today, to learn more about this topic. I want to thank our audience for their attention, their questions. We have recorded this, and we will make it available to you tomorrow, so you should see an email with that. Michael, unless there's anything else in closing that you'd like to say, I'm going to end the webinar and bid everybody a good day and I'll follow up with you separately.
Thank you very much for inviting me to this presentation, Brian. I appreciated the opportunity.
Good. All right, well, I'll talk to you soon, and thanks again for everybody for tuning in today. We'll talk to you soon.